Okay, well, we'll see what happened. Let's go.
Welcome to What Had Happened Was.
When we take a peek into actual court cases and give you commentary based on our unique perspective and experiences, and also give you informational tips and tricks to help you avoid a what had happened situation.
Before we get started, give us a thumbs up, a tasteful comment. Subscribe to the channel to be notified of every video as they come out. All defendants are considered innocent until proven guilty in a court of law.
All right, this is the 1 p.m. calendar. This is Ada Melina Costin Cruz versus Diaris Nellums, Peachtree Truck Leasing versus ProMed Imaging and Unified Medical. But essentially, the case took a turn because at the last meeting, the attorney for Costin Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, I guess, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist.
So he had submitted a document created by AI?
Correct.
What in the...
Lazy.
No, that's not even... That's beyond lazy. That's beyond lazy because, you know, that's a miscarriage of justice. Is what it
gross
is.
Miscarriage.
It's a gross miscarriage of justice.
I agree with you.
And it's not fair to the client.
No, it's not.
Because whether he was getting paid for it, it was free. They have a whole application for citing things called Westlaw.
I think somebody's been watching Star Trek too much. I think this is, you know, the computer where they can just generate anything. No, it's not a database. It's AI. Continue.
No, I don't even think it's about watching anything on TV. You can't blame that. That's just, that's bad. That's bad. Because there is a subscription that lawyers have called Westlaw that you go in there. It's everything that, every case, everything is now on there. So what, he didn't pay the subscription fee for that? That's why a lot of lawyers like to be with firms, because that gives them access to all that information and all the cases, and they don't have to pay the subscription. They just log in and they just do everything. And that's why a lot of them like to be part of a firm. You don't have to have all those little extra expenses.
Right.
But to sit there and go on AI, and AI basically created a case.
Right.
And now you submitted it. You didn't even check behind to see if it was a real case.
Which is what lawyers are supposed to do. They're supposed to fact check and accept through Westlaw and make sure that this stuff is legit before they submit it to the court. Because now
this would have been fine. I would have even accepted this more if it would have been a person that was representing themselves when they kind of did this.
Right. That makes Exactly.
I wouldn't have really accepted it, but I would have accepted it.
You'd understand, yeah. But at the same time now, this lawyer left himself open for disbarment and sanctions. That's ridiculous. Unnecessarily, because guess what? What you've done now is you submitted it's a perjured instrument, yes. A false document. A document is for, this can also lead into criminal charges, because you have to swear and attest to this to be true under penalty of law, and now you just sat there and submitted, it's perjured testimony. Perjured affidavit is just as bad as a perjured testimony. It's the same level of crime. It's ridiculous.
That's a white collar crime, basically.
Yes, it is, basically. No, this is going to get really.
And how long has he been a lawyer?
I don't know. We'll find out in a second, maybe. Even we make sure when we do these videos, we make sure we go over the video again to make sure it's everything that we said is what we said. It's accurate. We don't just babble.
We're just two people having an opinion. He's a lawyer. He has a degree. He's there. He's being paid by either the state or a private firm or whatever to represent a client. That is a gross miscarriage of justice. You and I are two people spitballing on a YouTube video.
But we have some facts in our heads as well.
It's irrelevant.
I agree.
I did not sit there and say ChatGPT. This is a person's life he's playing with. Whether It could be a criminal case, a civil case, or whatever. It is
and there's a dollar
someone's
value
life.
attached, and I'm paying you for your expertise, but you're not providing it. Yeah, you get. Yeah, I agree with you.
He could have used the app for that.
And so the court made a record, assisted by the Mr. Kennedy, who's the attorney for the defendant.
They were in the state of Georgia, in Clayton County, with Judge Hayward in her court today. This is a civil case, apparently.
Who had gone through and basically noted all of the instances where there were documents, where there were cases cited in the document, but they did not, were not actually cases under Georgia law to which the court could lean for legal authority. All right, so at that point, I informed Mr. Gillespie that I would be sending this information to the state bar, which I did. And I have not heard back from them other than that they have received the information and it is in process with the general counsel for the state bar. But I did tell Mr. Kennedy and Mr. Gillespie that we would reconvene to determine what sanctions, if any, the court would.
Yeah, they need to have some sanctions.
Yeah.
Because I don't know how you fix it that you're going to just have AI create a brief for you and not even check behind it. And he just submitted it.
Right.
So that he was fully confident that what it said was, he didn't even run it through anything.
No fact check. No one to go behind and to double check the facts or to cite the actual cases, which you're supposed to do. So when you submit a case and you use a case as a reference for your argument, you have to, the judge has to be able to open up the law book and cite the case what the argument was and
see and tell you if that case does apply,
right,
or if it doesn't apply.
Exactly.
To say, oh well, you know what,
in order for them to make an accurate ruling.
I don't know.
This is crazy.
I feel like, this is just my opinion, but I feel like he should be disbarred.
Yeah.
And then I don't think he should be able to, because these are the same thing like a paralegal will get fired for doing something like that.
Yeah, exactly. The paralegal is the one supposed to be doing all that double checking for him.
No, but I'm saying if a paralegal did it,
yeah,
they would get fired
immediately. You know that, yeah.
If they got fired, if they went to court and they said, "Oh, this is not legit," they would get fired.
Yes, and brought up on
charges.
They wouldn't stop just fired. That'd be the least.
And so, how you're the entire lawyer,
right? Because now this brings a spotlight to you and your integrity as a lawyer.
So now I want to
officer of the court.
And now I want to know about all your other cases. What have you been doing since technology hit? Because
right.
Who knows how long? And you might need to take the bar over, because I don't know if you use technology to help you pass the bar either.
Yeah.
I don't know.
Depends how old he is.
Yeah, I don't know how you know. When did he get his law degree?
Yeah.
So are you like a crib sheet cheater? Are you a person that used to write your things, like wrote the answers or whatever? You're hiding it on paper. You looking at other people's things. I don't know when he got his law degree. I don't know. I question now everything you've ever done.
This is what happens when people go and they have cases.
I want to know.
That's why lawyers. I'm sorry for cutting you off. That's why lawyers and police officers and anyone that's in the legal authority over other people are required to hold themselves to a higher standard, because of the fact that everything you do could disrupt or dismantle a lot of the judicial system in cases of people or left themselves open to legal liability as a result of you not citing the case properly, or you're taking a shortcut here. And because of that, now you left yourself open for scrutiny of all your cases. That's what you cite. That's what you tried 1,000 cases. Now all 1,000 of those cases now in question and could be possible financial consideration or penalties.
There might be somebody sitting there right now that said, "Oh, he was my lawyer, and as a result, I didn't get treated properly or whatever. Exactly. I need my case retried or whatever."
Exactly, and that's what they leave them open for. This is how sometimes people get to go free because of legal loopholes like this.
Impose. All right, and so I have Miss Middleton. Yes, ma'am.
Good afternoon, Your Honor. I represent Plaintiff Cruz. We filed an entry of appearance on December 31st. I left counsel a voicemail this morning, and we do have plans to connect after this hearing.
All right. So, Mr. Kennedy, I did ask you for your suggestions for the any sanctions that the court might issue in this case. But I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct.
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to verify or validate case citations and
large language models.
Madness.
You use artificial intelligence, and I don't even know. She should ask him. I need you to submit the prompt that you use to create this thing, and now we'll really see what he did. Because when you do these, you have to do a prompt. You have to come up with a prompt. Cite me a case from da 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 da. Well, he'd have been better off using regular Google.
Yeah. Here's the thing also, the other thing as well, the fact that goes back to us about being lazy. This technology is new to everyone. It's not just new to him. It's new. He's really, if you listen to him very carefully, he's not taking accountability for what he's done. There's some serious.
I understand he's not taking accountability. He's trying to sit there and say, well, the robot did it. You asked the robot for it.
And he's minimizing his involvement in this.
He said, well, I didn't know it was going to do that. You asked it for it.
Yeah, you knew beforehand.
Once again, she should ask him, what was the determination that made you think that you were going to use it? She has to go and get it all on a record. I need it to be transcribed, because once again, all of this is going to go for his, when he goes before the Bar Association. Well, maybe they'll ask all those questions.
Who knows? But the report's done already, so this is just a follow-up.
Yeah, but still asking the questions. What prompt did you use?
I think that was enough. I think that was.
No, I'm not saying that. I'm saying to myself, what prompt did you use? Because I know you can use AI and be like, beautiful woman standing by the beach. She's wearing a blue bathing suit and she has 2 cookies in her hand.
See, but the prize a two-edged sword, because now, in order for him, he said, I confess. He didn't confess nothing. He just saying I messed up. If he's actually confessed and be honest, he would sit there and say, well, Your Honor, because I based on what he said, this is the only thing you can say. Your Honor, I did this in another case, which you'd have to admit that. And say, and in that case, it was this, that, and the third. And I actually went behind.
He's not going to say that.
I went behind the chat GPT, and I saw that it actually cited the proper cases. And as a result of that, I felt.
He's not going to say that.
No, he's not.
That's going to make a review of another case.
Exactly.
But
he'd have to further incriminate himself.
Everything should be reviewed. I'm sorry. I think from the time he took the LSAT, it should be reviewed. Because
did he use AI for his LSAT?
You like shortcuts.
Yeah.
That's a shortcut. And here's the thing, once again, Westlaw has been downloaded and has been up for years now.
Right.
But it's not like
it took them years to upload it.
But that's what I'm saying, that every case is going into Westlaw now. So that's why these cases, well, as soon as they get transcribed, they go into.
I'm sorry, what is Westlaw?
Westlaw is the subscription service that the lawyers have. It's like the library of cases.
Thank you.
It's the library of cases.
Need to be said, because some people are like, what are they talking about Westlaw? What? That's what Westlaw is.
It's what the library of cases.
Right. They're actual books back in the day, but now since we're in the digital age, they've made it so you can have basically Westlaw in your pocket if you want to refer to it.
So now a case that goes on in Georgia, as soon as it gets transcribed, it goes into Westlaw.
Right.
The ruling or whatever goes in, and someone could cite that same case the next day.
Right. And have the case, the argument, what cases were used.
That case can be used argument. The next day.
Right. Exactly.
Or as soon as it's finished or whatever, it's included and it's put in. So, and he used, I don't want to say ChatGPT, but he used some sort of artificial intelligence.
No, yeah, okay.
Because I don't want to blame one app or another, because at the end of the day, it's the person that used the prompt.
True. Yeah.
Or did a secretary? Like, who did it?
Someone.
Who did it?
Somebody.
Was it you or was it somebody else?
Somebody got going to that bus quick.
Or did you ask like your son, hey, look this up for me? And he was like, oh.
Okay, Dad. Let me finish my homework first.
And so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
He's not even backpedaling. He's like going around it.
I told you.
He's not even backpedaling. He's just going around like saying,
no accountability.
And he said, what about subscription service?
He said, after he got his hands caught within the cookie jar, he turned around. Then there is an actual service he could have used that's computer generated for legal service, which now he wouldn't pay for his subscription. Maybe he would subscribe to Westlaw. Maybe he has it now. He said there is actual.
He was playing fast and loose.
Yeah, that's what he did.
He was playing fast and loose and got caught. And now he's like, well, you know what?
Because now, real source, because cites real cases, because it's based on their database is based on actual cases. So there's no error for mistakes.
But here's the other thing about that. He did it after, not before.
If he would have got away with this, he would have kept it pushing.
He would have kept going. He tried, like I said, he's trying to backpedal and go around. He's trying to say, well, I have it now, so, it's okay now.
I think, this talk of disbarment in the bars, let's not be quick to fast judgment. You sound ridiculous. You sound crazy. That sounds ridiculous.
That's bad.
Because now you're showing you're showing your colors are showing so what kind of man you and what kind of integrity and moral turpitude you stand on. This is ridiculous.
I know.
This is nonsense. And now it's let's not talk about sanctions yet. Let's see what they're gonna say. No.
Let's see what they're gonna say.
Yeah. In the meantime, you need to not do anything until this is straight. Yeah, and just deal with the fact that you messed up.
Big.
Okay. Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction.
Basically, he wrote a story.
Aesop's fables.
He wrote a story. And pretended it was a case.
Right. And she's saying, he's trying to say, well, Your Honor, it's too early. You submitted a report to the bar.
I'm supposed to submit
Let's wait and see what's going on with. They say, wait a minute, hold up now. In spite of the fact that I submitted a report of your misconduct to the bar, you still submitted a document that was a work of fiction. And because of that, everything you
This
submit,
case can't
everything you submit
proceed.
to the court, you're affirming under penalty of law that this is factual and true. And you submitted something that was fraudulent before the court. You are now subject to penalties, criminal as well as civil, as well as punitive damages. And again, it's a travesty. It's complete contempt of court.
But
we can go on
also,
with
this case has to basically pause
Right.
until they get this together. Because now it's like, do we take him off? They're gonna have to take him off the case and get the person a new lawyer. So now you got to find out if this is a paid lawyer. If he was a public defender, he would have probably got suspended.
Yeah, but now
they have Westlaw, so yeah. I don't think.
But at the same time, well, I don't know if he's a firm or he's a private practice.
Once again, that's
but
what I'm
if he
saying.
has a partner, then he just has to someone else will be assigned to the case.
But once again, that can open an investigation to their whole. Listen, if it's a law firm, they'll ask. They're gonna ask. They'll pull the whole firm in and ask questions. I mean, I would.
Well, yeah,
because I want to know what y'all all doing now.
You brought the entire firm on investigation, yeah.
Because now all these things have to come out to light because you did something that and would another lawyer be like, oh, I use Westlaw, so why is he not using Westlaw? We use Westlaw. Well, I don't know what we supposed, or what he didn't want to pay his share that month.
I don't know.
And so, based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Caston Cruz because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 915.14, I would ask for my client's reimbursement of all of our fees.
Playing from Tristan's iPhone.
Was that his phone talking?
I think so.
He didn't put it on Do Not Disturb?
I don't know. AI is interfering in the case directly. What is it? The rise of the machines
the
going on?
robot is completely taking over.
You cannot sanction me, Judge Hayward.
Oh my goodness. Are you serious? I can't even.
You can't make this stuff up. Oh my gosh. Did you see Judge Hayward's face, that face she made just now?
Oh my goodness.
She is not happy about this. This is just adding fuel to the fire.
All right. Don't know what that was.
Ahead, sir.
Yep. All of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's written documents submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And, we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. I mean, we called it out and we asked him what was going on, and the response was, you want me to provide additional briefing, or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolved all the prior behavior and sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. I mean, my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further, but I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say. And so that's exhibit D to that motion. It's my affidavit of fees.
The case should be dismissed.
He said all that to say, I think I need that to go, Jan. I need,
Yeah, and they should be reimbursed because they paid for a service and they didn't receive it.
This case has been going on for a year. A year. That's a lot. That's a heavy expense for anyways. An e-company or on the web. That's a heavy expense.
That's fraud.
That's fraud.
That's fraud. Yeah. So he's been defrauding them for a year.
So this is the plaintiff is suing him. The plaintiff was the one that's using the AI to cite their cases to try to win this case over them for whatever the argument is. He's like, listen, we've been sitting here going through this nonsense. My client actually has a lawyer that's actually doing the work, and this guy's playing.
I'm quite sure he looked at that case and was like, where was that case at?
Yeah. Yeah. When you see the documents like that, I got the posting discovery, I get a copy.
Right. And he was like typing it in like, wait a minute, what's this case?
And like, this ain't no case. Like that's how this all came out. So again, I agree. I get what he's saying. He's like, change your lawyer and to say, okay, we got a new lawyer. No.
Dismiss the case.
Dismiss this case. Dismiss this case. And if you're not dismissing the case, you should still be reimbursing me my money for this up until this point because of the fact that, again,
it's been a waste of time.
Yeah, it has
been a waste of everybody's time.
Everyone.
The court's time, the judges, the defendants, everything. And are they being held?
It's a civil case.
Civil case. But they still have to come to court, lose a day's pay or whatever they have to do.
He's like, this is Zoom. He's like,
that doesn't mean anything.
I don't even know if he's even home.
That doesn't mean anything.
I mean, at his office, he has his background. You can see his background. The guy in the lower right corner. He's obviously has something behind him. He could be. It's rather because he's at home in his den, sitting there.
No, I'm talking about the defendant.
The defendant's in his office. Everyone, this whole case is on Zoom.
Yeah, but you losing money while you're doing this.
Yes.
Because even if he has to appear, even if it's for 5 minutes,
right?
It's 5 minutes. He has to take himself away from whatever he's doing that makes his money to attend this case.
Well, from what I remember, billable hours are increments of 15 minutes.
Yeah, well.
So even if I spend only 5 minutes in your case, I still have to charge you 15 minutes.
Exactly. So either way, not good. That's it in my once pockets. Again, like I said, somebody's still paying for this, and somebody has to pay for this.
Yeah, and so now, and that's what's going on.
All right.
If I may add, Your Honor, we don't disagree with the procedural history of this case, but we would like to object to counsel's dismissal.
Wouldn't be my dismissal, it would be the court's dismissal, but.
Well, your suggestion of the dismissal.
Okay.
Dismissal. Okay. All right. Well, you say you're objecting. You got to give me some basis for your objection.
Yes, Your Honor. So the plaintiff here has terminated previous counsel. It's my understanding previous counsel has also been terminated from the firm as well. My basis on the objection would be that plaintiff had, no idea this was going on, and as such, shouldn't be prejudiced because of this. My goal would be to get this case back on track. It's my understanding there was a consent motion to discovery filed with discovery expiring, I believe, the first week in March. So we would want to be as diligent as possible and still maintaining that deadline and getting the case back on track.
I want to be mindful that the parties in this case are not the primary drivers when it comes to filing motions and attending to court processes. And so if I'm going to sanction in any case someone who's acting on behalf of the parties, if Ms. Caston Cruz is unaware that her attorney is filing fiction, it would be unnecessarily punitive to her. I get that the case has not moved in a manner that is expected. But civil cases tend to have issues with timing anyway. Civil cases can, there's no real expectation of how long a civil case is going to take. We hope for things to be done in a timely manner. We have a structure for how discovery should be conducted. We have a structure for how cases should proceed, but mere timeliness is not something that we can really, that's really a factor that we can guess about or know about from the outset. What I do have is a desire to make Mr. Kennedy's clients whole, in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had
so it was ChatGPT.
Yeah, but unfortunately, now this app comes under all the scrutiny for something that it had nothing to do with it, because this is a dealer's choice. Well, this is a dealer's choice.
She's not saying that ChatGPT doesn't work. It's just not for this. Not when it's comes under my pockets and legal authority. This has got to be right. Yeah, but
now they're trying to sit there and say, well, the case. Cause go back to what they said about the case. They said that a civil case takes as long as it takes.
Right. Yeah, that's what she's saying.
But when he submitted this information the way he submitted it, was it suborned perjury?
Right. Now he took it to another level. He submitted a perjured instrument before the court, which is subject to being scrutinized under the legal authority of the court, so now, and subject to penalties of law.
So that now the wheels of justice can't have to stop, because they have to fix what's wrong. And this is why the people say the system is crooked.
Right. And this is also how case law gets started as well, because of stuff like this. And right now, this is case law being presented now. This is going to be a test case.
Because if he thinks that he's just going to be like, I'm sorry, and he's going to write 100 times, I will not use an app for an app to make a legal case. He thinks he's going to write that on a chalkboard. He's got another thing coming.
I know he would. He'd get someone else to do it, because he's that lazy. He's not doing it. So that's going on.
A training for judges about the use of AI. And essentially the main thing that was beaten into our heads was, you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings. But you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. It is software for people. One of my friends uses it as, she says, like, it's like her wife. She'll say, hey, make a grocery list. Hey, write this letter for me. Hey, set up a schedule for my children. And so it is assistive in that way, but you are responsible still, because I'm so old school that this is the phrase that keeps coming to my head: garbage in, garbage out.
Yeah, so
even the judges have been trained about AI.
They went to training because this had to. Someone said, you know what? We have to bring this up because this is a different technology. You cannot use this. This is what you have clerks for. This is what you have.
And they knew that this is a possibility for potential for something like this happening. They said, you know what? That's what they said. They stressed that you are still responsible for anything that you submit or write and submit for a court as a legal authority. So it's matter of fact that they use ChatGPT. It's an open source format. She said it's not just for special. So there are AIs that are incorporated for the workload. I guess they consolidate.
No, they could say create.
They can read the case is lengthy. You can read the case. They can summarize it for you.
Right, but the case is still, it's an actual case.
Right.
But they could even say, tell me the next Monday, the next 3 Mondays in January. Give me the dates of the next 3 Mondays in January if they're in November, to kind of get a date ahead to know, oh no, this is this weekend is Martin Luther King Day. You can't use that because remember the court is closed that day. So they'll say, oh, tell me the next 3 Tuesdays in March, so I know, because remember, they all have their schedules when they do certain things. So they might use it,
as you said, assist with the
as
workload.
to assist.
Yes, assist. Not to make an ass of you, just to assist.
To assist.
Yes.
Create a schedule where Thursdays are just, we have these cases or whatever.
So he did all that to find the Harvard that he could have just spent to take a couple extra minutes and could have said then took a couple extra dollars and not be in this mess he's in now.
Which we were all told when at the outset of, and I'm old enough to go back to when we switched from typewriters to personal computers and to software, to the software for personal computers that allowed us to type and produce documents. And so at this point, I'm not inclined to dismiss the case because I really feel like Ms. Caston-Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case.
So this case is a headache case, period, no matter what. She's saying you have no idea of other thing, of all the other issues that popped up in this case that have nothing to do with the case itself, but it's on this case. That's
right. And now you add this other little
glitch, to it, which compounds this even more.
Because now they have to sift through the whole thing again. I feel like they should dismiss the case. I think this case should be dismissed because you know what? It's not even, and I'm not giving I'm not saying it's better, but it's not even a defendant trying to get themselves out of the problem.
Right.
It's the plaintiff
that's causing the problem.
Causing the problem.
And this is not the first lawyer they had on the case. They were doing that. They were trying the case.
So this is just baiting and switching.
Yeah, and they fired the other lawyer and grabbed this guy and threw him up in there because I guess he fits the profile. Now I'm questioning the company that's suing them because now if their lawyer's sleazy or not doing everything above board, now what kind of company you're
and why are you suing them?
Right. So it might be like it's a frivolous lawsuit. This is definitely not good.
However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court, and giving case law and statutes upon which the court can rely. And so with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, it was $25,498.08. That's fees and costs.
They're not playing for peanuts. It's $25,000. That's a lot of money.
It is, yeah. Yeah, that's not chump change. If you don't know, that's a lot of money.
I mean, you know.
And 1 year legal fees. That's
legal fees,
yeah.
And that's not even the damages or whatever it is or whatever. This is just what they've been getting billed and everything
for this case in the last year.
This is not even.
You have no idea what he's suing for,
right?
Or how much they're suing him for. But right now, dealing with this case has cost that company $25,000.
Right.
And it's not over yet.
They don't know how long it's gonna be.
Right. The judge said normally civil cases take a long time. There's no time. That's why there's no time limit on civil cases.
But now he threw this little
monkey wrench into the mix. Yeah, that's ridiculous.
All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am. And then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
Now he's trying to back himself out of it. Like,
he did say all. I heard the word all. Is that all? He said yes, all my fees. He said, I filed it up until August when I filed that. That's what it was up to. So even if he has a charge today, he's not charged before today. He said as of August up until today, that's the total cost. Period. We're not gonna worry about today.
Right. Today is my gift for you.
That's it.
Because it's the present.
And it's still not enough. And he said, you personally are responsible. Go and dig in your pocket.
Because the judge said that they're responsible for their body of work.
Yes.
You're responsible for your what did she use the phrase? She used the phrase you have to manage your work product.
Yeah, that's it. Manage your work product. Yes, you did.
So that means that whatever you're producing, which is what a product is, what you produce, you have to manage it.
A legal brief is a product.
You have to make sure that it's clear, concise, it's submitted, everything. Come on. You have lawyers that are first-time lawyers that are get in trouble because they don't file at the right time, or like when they have to file before 5 o'clock, and they have to get there before 5 o'clock, and they have to have it stamped before 5 o'clock.
Yep. That's why a lot of new attorneys, when they work for these firms, the first year all they do is just they spend the whole year in that law library. They're the ones citing them cases. That's what they do.
No, but
first.
I'm saying like when they have to submit paperwork.
I get it. Yeah.
But when they have to submit paperwork, it has to be before 5 o'clock. It's before 5 o'clock.
Right.
Which means that if you get there at 5:01,
it's done.
It's not counted until Monday, which means it was late.
Right. Which means he didn't manage his work product.
Yeah, he mismanaged it.
Yes.
He
got there. That's why he got there late. So yeah.
He should have had some AI set an alarm for him. That's what he should have did.
Yeah, that could have been accomplished very easy.
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court, and in this case, so I'm not going to nitpick at this point. I feel like from the outset of a case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file, if you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that is an excessive amount. So $25,498.08, that's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
That's Judge Hayward's legal way of saying Mr. Gillespie has to put an H on his back, on his chest, and handle it.
That's your thing.
That's H on your chest and handle it.
That's what you did. That's what you have to do.
I don't know. You trying to nickel and dime him now? Okay. Is that itemized? Listen. You see what I'm saying? No accountability. This wouldn't have been a problem if you would have did what you were supposed to do.
Exactly.
What's that thing with Woody's? I like what he said.
Oh, if you were Woody, would have went straight to the police.
Please, just do that.
If you would have did what you were supposed to do.
Yeah.
This is to make sure that $25,000 later, you won't do it again.
Right. Because there's a good chance you might not be disbarred.
Judge, is there a timeline you want to put on that?
120 days.
And would you like a proposed order, or will you have one?
Please submit one.
Okay. Your Honor, if I may, I know you've indicated you're not inclined to, dismiss the case on a sanctions ground. Are you planning on taking up the summary judgment motion today too?
Ms. Middleton, you're just coming into the case. Can we get back on track with the merits of the case?
I believe so, Your Honor. In all honesty, I have not had a chance to really take a look at that motion for summary judgment. I did see some mentions of reopening default in the docket. If counsel's willing to get this back on track with discovery, I mean, we would have no reason to oppose that, and I'm happy to get on a call with counsel once this hearing wraps as well.
Here's my only issue, Judge. So I filed this motion for summary judgment because they didn't respond to requests for admission, right? So under OCGA 1136, those are just deemed admitted. And the case law is very clear that to overcome those deemed admissions, they've got to provide credible, admissible evidence that would refute them. And there is none right now. I mean, they filed a reply brief that had an affidavit from their client that is inaccurate, and we can go through it if you want. I can show you exactly why.
So not only did he give a perjured instrument, it wasn't right, and he was requesting a summary judgment because of the fact that they sent a response to his thing, and he didn't respond back. And that's also how you can lose a case. If I send a document in and my arguments, and you don't respond to my arguments within a certain time, you will lose the case on the merits that you didn't respond in a timely manner. So you used AI and still didn't respond in a timely manner. And on top of that,
your robot was late.
The robot was late, and the robot had inaccuracies. It's not. It wasn't. Because that's, you remember, just like like with a parking ticket. If you get a parking ticket and it says, and today's Tuesday, and it says Wednesday on it, the case is dismissed. It's wrong.
Right.
It's inaccurate information. So now as a result of that, on the ground, and I'm requesting. I'm requesting.
It should be dismissed.
Dismissed on the ground.
It should be dismissed.
The
AI should make it automatic dismissed.
So he already had filed for summary judgment because they never responded. The robot was late. The robot didn't manage the body of the work product in the timely fashion that they got to the court late. I don't know what slowed the robot down, but they got there late.
Well, because he didn't tell the robot to do anything.
He would set that alarm.
She's got, first of all, a different date of a motor vehicle collision, saying I was involved in a motor vehicle collision on January 4th, 2024 on I-20 in Douglas County, Georgia. And can I share my screen on here?
Your Honor, if I could be excused, I know a lot of this going forward doesn't pertain to me.
Yes, Mr. Gillespie, you may be excused. We'll get you in order.
Can you see my screen, Your Honor?
Yes, sir.
Okay, this is the police report from our case. As you can see, I can try to.
I have December 14th, 2023.
Right, in Gwinnett County. Totally different day than in her affidavit, sworn affidavit that has been submitted to this court, which again is just kind of consistent with how things have gone, says that this is the day that she got in a motor vehicle accident and was injured. I mean, I don't know what to do at this point. That's all. The only evidence they have, apparently evidence in quotes, is this affidavit from plaintiff that says she was injured in a motor vehicle collision on a completely different day that she supposedly received medical treatment for. But then again, we've got these requests to admit that they're deemed admitted that basically say, my medical treatment wasn't caused by this accident and wasn't necessary, and those sorts of things that just completely defeat her case. So at this point, I'm not sure there's a lot to even argue on their side as to how they overcome a summary judgment motion. So that's why I was asking I know you're not inclined to dismiss it on just a pure sanctions ground under 915-14 or because of the contumacious conduct to the court, but I think I'm also entitled to you granting summary judgment in my favor.
All right, Ms. Middleton.
I mean, the fact that there's a police report showing that the wreck happened, I mean, obviously there's some meat there. I mean, we would obviously object and request for an additional 30 days to respond to the motion for summary judgment, if you would be inclined, Your Honor.
Well, kind of not, because at the point where I guess you came into the case, we had been dealing with the sanction issue, and that has been more than 30 days. So from that point, Mr. Gillespie and the firm and whoever he's dealing with had noticed that there was a pending motion that the court did not hear, and that there was time at that point to address that pending motion or to come up to speed on what that was. And at this point, the court's not inclined to continue to delay this issue. To Mr. Kennedy's point, if the discovery is deemed admitted and we're dealing with the basis of, okay, these facts are a part of the record, then you have to come with the strongest evidence to show that the deemed admitted facts have that there is something to counter those facts that have been admitted by failure to respond to discovery. So just the fact that there are two police reports or two incidents of an accident, one in January of 2024 and one in December of 2023, the existence of those divergent things is one thing, but none of that is enough to overcome what has been admitted.
I'll also just point out that she also in the affidavit says that she was struck from the rear by a vehicle. And I can pull back up, but the police report from our case, she was backed into. So it's like a completely different mechanism of the way the accident happened too.
And given the procedural history of this case, Your Honor, I do think we have good cause to possibly withdraw or amend those omissions. Um, you know, I would want to move to do that.
Well, that's already been done.
This is
I know.
this is the issue that I'm having though. Y'all have I don't know how you got into the case, Miss Middleton, and so I don't want to beat up on you too bad. But the issue is that y'all have had plenty of time because since we had the first sanctions case, I know that was probably sometime in early October, or I feel like it was October.
August.
It was okay. It was August because I've gone to judicial training since then. I've come back. We've had the holidays. So since August, we've had a substantial amount of time for you to file whatever you wanted to file. Because had I decided to accept your filings, fine. They're already on the record. Let's deal with them. But I didn't restrict anybody from filing anything. The only thing I asked for at the point that we left in August was for information about the filings that involved Mr. Gillespie and the sanctions. I don't know when you came into the case, but there was plenty of time entering the case to file whatever was necessary to protect the rights of Ms. Caston Cruz. And so if you didn't make use of that time, there's not a lot I can do in this case.
Well, and Judge, I mean, they did file a response to my motion for summary judgment, and they did file a motion to amend or withdraw their deemed admissions. It's not like nothing's been briefed and been filed. I mean, this stuff was all briefed and is in front of you and was briefed back in September and August and October.
The issue is though that I don't have a lot of information that says we need to overturn the admissions and reopen that part of the case. And also, I'm kind of leery of what was filed because it was filed by Mr. Gillespie. At this point, the court has no confidence in the validity, viability, or legal basis of anything that Mr. Gillespie files with this court.
At this point, nobody's going to believe anything he says.
No,
I could be standing right next to him and it could be pouring down and he could say it's raining. I'm still going to look at him like, what?
Well, are you sure?
Are you sure? Even though I'm looking at it too. Just because he said it.
Right.
Nothing he says is credible right now.
Nothing
he says is credible. He lost it.
So am I taking that as you're disregarding basically his response briefs and the pleadings, the briefs he's filed? And at this point,
unless I'm hearing an argument from Ms. Middleton.
Again, Your Honor, we do not disagree with the procedural history of this case. We started the case on November 26th. We have been having difficulties getting the file. So, I do apologize if my knowledge of the case isn't exactly in alignment with the procedural history of the case. So I do want to be honest about that. But, again, we would want to move to withdraw and amend the admissions, based on the previous procedural history of this matter.
So when you came into the case, you came in relying on what Mr. Gillespie filed and you didn't file your own or amend?
We did rely on the Felicetti firm, which was the firm that Mr. Gillespie worked for. I knew that he relied on ChatGPT for the filings, and I knew that was an issue. But in terms of the admissions, I really wasn't aware of that.
The issue is, and I know you know this, Judge, so this isn't going to educate you, but the problem is for them to be able to withdraw and amend their admissions, they have to show that the admitted under InterSouth Properties versus Contractor Exchange, which is 199 Georgia App 726, the admitted request either can be refuted by admissible evidence having a modicum of credibility or is incredible on its face. And at this point, there is no evidence in front of you at all to refute the admissions. I mean, that's the problem.
No affidavits, no certified copies, no
medical record
filed with the,
There's just nothing. So there's one 5-paragraph affidavit that we've already shown is not even reliable. So I'm sympathetic with Ms. Middleton. She's only been in the case for a couple months, but at the same time, you don't always inherit the best cases, I guess. It's just how it goes sometimes.
Well, and this is what I say. In knowing the procedural history of the case, at that point, if I'm coming into a case that is problematic, I would amend the filings. I would ask for leave of court if necessary, but I would definitely amend the filings that were already done to preserve the issue, but to amend them to perfect them such that by the time that we actually argued the case, then the amended filings would take care of whatever deficits were done before. There's nothing that prevents you from amending a pleading. There's nothing that prevents you from, if your response was done by the previous attorney, coming in and amending and updating that response or providing additional evidence that would support and give the court a basis for the decision to overturn the fact that the admissions had been deemed admitted.
Or bringing evidence or witnesses to this hearing. There's a lot of ways to do it. But Your Honor, I think you could issue an order in such a way that it wouldn't extinguish any claim that the plaintiff may have. Not against my clients, but if that's of concern.
Is this a first filing? This is not a refile?
To my knowledge, it's not a refile.
My knowledge as well, Your Honor.
Although, if I'm not mistaken, maybe I'm getting my cases mixed up. I think the complaint says it's a refile, but I was never aware of a first filing. I'm gonna look right now.
All right. Okay, so the court is going to make a decision in this case. And I will issue an order. Mr. Kennedy, if you will get me an order on the sanctions, I'll go ahead and sign that.
Okay.
All right, Ms. Middleton, the cases are what we get. I was in civil practice too, so I understand that sometimes if you take over from another attorney, it kind of is what it is. But let me have some time to consider all of the. I'm not a superior court judge, so I can't balance the equities, as it were. But I do have to consider, fairness and balance those things that would affect each of the parties in this case. So, all right. Thank you, Mr. Kennedy. Thank you, Ms. Middleton. And we will get an order out to you.
Thank you, Your Honor. The only, before we go, if we could, and this may be something that I can work out with Ms. Middleton, I don't know, but we do have the motion to open the default as to liability and set aside the liability judgment as to Peachtree Truck Leasing Company.
Peachtree Truck Leasing, right.
Right, which we were going to take up in August, and then we never got to it.
Yeah. So what we had talked about was the default was in, and then we were talking about whether damages hearing would prejudice the remaining parties in the case because of the information that had to be presented during the damages hearing. And so That's sort of where we left it before all of the issues with the briefs.
Right. And so you already ruled that we couldn't have a damages hearing because there was still one defendant that wasn't in default. This is a slightly different issue because I'm asking you to open the default and set aside the judgment as to liability as to Petrie Truck Leasing altogether because they're an improper party in the first place. And I told Mr. Gillespie, but I'll tell Ms. Middleton now. I know who the proper party is. I've put it on all the briefs. And all I'm asking is that we just swap out the parties so we get the right entity in here. I'm not trying to hide the ball or extinguish any claims or anything. We're just trying to get the proper parties in. And Mr. Gillespie was, I guess, holding on to his default judgment that he'd gotten as to this Petrie Truck Leasing, which again is not a proper party, and we didn't want to agree to lose that. I don't think the plaintiff is prejudiced at all by getting the correct defendant in here and litigating on the merits since we already have Mr. Nellums has not been in default at any point. But that's the issue there. And again, maybe
You mean to tell me this whole time he had a better way to get out of it?
Yes.
A legal way to get out of it.
Yes.
And he sat there and so once again I question his integrity. His integrity because he could have had he paid he's lazy. Because had he been paying attention, he would have been like, what am I doing here? I'm not supposed to be here.
This is not up to be us. We're not supposed to be suing this guy. We're suing someone else. Yeah.
There you go.
I agree.
Okay, let me ask this. Do you also represent the proper entity?
I do, yes. So there won't be any issue with that.
All right.
Yeah.
Yeah, we would not want to keep the wrong entity in, so we'd have no objection to that.
Okay. I can put that in a proposed order too then if you want.
Please do.
All right. I think that was the only other thing on the table.
All righty. Thank you all.
Thank you.
Thank you. Thank you, Your Honor.
Thank you.
So you see, all of this time.
It's not even the right defendant. That's just money being wasted. And he represents the people you're supposed to really be suing. I represent them too.
Oh, he's playing both sides to get the middle then.
No. This is a defendant, the one that's
He's
one being sued.
So that's why he knew that it wasn't the right person.
Right.
That's why the defense was like, I know this is not right because I know who he's supposed to sue.
True, exactly.
But I don't have to tell you.
No. You gotta figure that out on your own.
See, see.
He didn't ask AI that though.
He didn't ask the robot that. The robot would have told him.
Not the right guy. Sue other ABC company. I'm not too sure. Okay.
Thanks for watching.
And also give us a thumbs up, like, comment, share. Subscribe to the channel and you'll be notified of every video as they come up. And get that algorithm going and help us build this channel this year.
And make sure that you don't wind up in a what had happened situation. Boom, boom, boom.